Just those folks are reading these instructions along the court, I'm going to resume reading the concluding jury instructions beginning on page 11. And this is punishment for life imprisonment. When you deliberate on this case, you will make a determination as to whether or not the state of Tennessee has proved unanimously one or more statutory aggravating circumstances. And those circumstances, again, are that defendant has previously been convicted of one or more felonies other than the present charge, the statutory elements of which involves the use of violence to the person. And if you find that to be true, beyond a reasonable doubt, you don't have to find all the others to be true, and you must be unanimous as to whether or not you find that to be true. You will also consider whether or not the murder was committed for the purpose of avoiding, interfering with, or preventing a lawful arrest or prosecution of the defendant or another. You also must find that to be true beyond a reasonable doubt, and that verdict on that also has to be unanimous, that you all unanimously agree that the state has proved that. You don't have to prove all three, but just one or any of the three or all of the three. You don't have to find all three, because one of the three is sufficient under Tennessee law. Thirdly, if you find that this murder was committed against a law enforcement officer, will not read the rest of the language. And if you find that beyond a reasonable doubt, the law rather says that you would then weigh whether or not there's been any mitigating circumstances that have been proven. You do not have to find unanimously, you do not have to find beyond a reasonable doubt as to whether or not there are any mitigating circumstances that have been proved in this case. That's an individual verdict that you make. But if you find that the state of Tennessee has failed to prove any statutory aggravating circumstances, punishment of life imprisonment would mandate that we, the jury, unanimously determine that no statutory aggravating circumstance has been proven by the state beyond a reasonable doubt. We, the jury, therefore find that the sentence shall be imprisonment for life. And all 12 of you will sign that verdict on page 11. You can only sign that verdict if you find that the state of Tennessee has failed to prove any statutory aggravating circumstances beyond a reasonable doubt. Does everyone understand that? The second verdict they can reach in this case is either punishment for imprisonment for life without the possibility of parole or imprisonment for life. Now, if you find that the state of Tennessee has proved the existence of one or more, one, two, or three statutory aggravating circumstances, but you do not find that circumstance or circumstances outweigh any mitigation beyond a reasonable doubt, then you have a choice to make. And this is the only instance where you have a choice. If you find the state has proved statutory aggravating circumstance but did not prove that it outweighed mitigation beyond a reasonable doubt, then the law says you have a choice. And the verdict would be, we the jury unanimously find that the state has proven the following listed statutory aggravating circumstance or circumstances beyond a reasonable doubt. And you would list in this space on the verdict that would be in the trial jacket what that circumstance or circumstance is, and you must list those, and as it indicated, it must be limited to those enumerated for your consideration by the court in these instructions. And those are the three things that I listed for you under statutory aggravating circumstance. And if you find the state has proven those statutory aggravating circumstances, but secondly, we the jury unanimously find that such statutory aggravating circumstances do not outweigh any mitigating circumstance or circumstances beyond a reasonable doubt, then you have a choice to make. And you consider discretion. You can either A, we the jury unanimously agree that the defendant shall be sentenced to imprisonment for life without the possibility of parole, or secondly, we the jury unanimously agree that the defendant shall be sentenced to imprisonment for life. And again, you can only deliberate on that verdict if you find that the state has proven one or two or three statutory aggravating circumstances, but it does not outweigh any mitigation beyond a reasonable doubt. If you find that, you have a choice as to whether or not you sentence Mr. Wilbourn to life without parole or life imprisonment. Does everyone understand that? Lastly, on page 14, punishment of death. We, the jury, unanimously find the following listed statutory aggravating circumstance or circumstances beyond a reasonable doubt. And you will list in this printed spot the statutory, the circumstances so found, and those must be limited to those that are enumerated in your instructions on page 4 of this charge. And if you find 1 or 2 or 3 have been proven beyond a reasonable doubt, you would list the 1 or the 2 or all 3. If you find the state has proven all those or one of those beyond a reasonable doubt. If you find those things have been proven beyond a reasonable doubt, the law and the court has also told you that victim impact statement is not the same as an aggravating circumstance, but you may consider this victim impact evidence and determine the appropriateness of the death penalty only if you first find the existence of 1 or more aggravating circumstances that's been proved beyond a reasonable doubt. So if you find beyond a reasonable doubt the state has proved the existence of 1 or 2 or 3 statutory aggravating circumstance, then you can also consider the victim impact statement, and you will weigh that against any mitigation that you find. And again, a mitigation does not have to be found unanimously. You don't all have to agree as to what is, in fact, a mitigating circumstance. After you weigh the statutory aggravating circumstance and the victim impact statement, if you found the aggravating circumstances to be proven beyond a reasonable doubt, and if you find that the statutory aggravating circumstances outweigh any mitigation beyond a reasonable doubt, number 2, we the jury unanimously find the state has proven beyond a reasonable doubt that the statutory aggravating circumstances or circumstances so listed above outweigh any mitigating circumstances. And the third part of this will be that, therefore, we the jury unanimously find that the punishment for the defendant, Tremaine Wilbourn, shall be death. And you assign each of your names to the verdict. This is not a referendum on a death penalty. This is not asking how you feel about the death penalty. This is not, as I told you at the sentence, at the guilt-innocence phase of the trial, this is not a menu. It's not a multiple-choice test, which you go back in the jury room and you make a decision. Do we want to give Mr. Wilbourn life? Do we want to give him life without parole? Or do we want to sentence him to death penalty? It's not a multiple-choice test. It's not a menu. You must, as the law would indicate, if you find beyond a reasonable doubt that the state of Tennessee has proved the existence of 1 or more, in this case there are 3, if they prove the existence of 1, 2, or 3 of those statutory aggravating circumstances, you apply the victim impact, and if you find that outweighs any mitigation beyond a reasonable doubt, your verdict shall be the death penalty. Does everyone understand that? And if you do not find that the state of Tennessee has proved the existence of any statutory aggravating circumstances, then you shall sentence Mr. Wilbourn to life in prison. Does everyone understand that? And if you find the state has proved the existence of 1 or more, 2 or 3 statutory aggravating circumstances, but do not find that it outweighs any mitigation beyond a reasonable doubt, then and only then would you have a choice, and you consider discretion, you can sentence Mr. Wilbourn to life in prison or life in prison without the possibility of parole. Does anyone have any questions about how you go about reporting your verdict in this case? Deputy Smith is going to bring to you the trial jacket, which has the final jury instructions in here as the indictment, and it also has the sentencing instructions and fixing punishment. And that's the document that you will record your verdict on. That document, whether it is the death penalty, life in prison without the possibility of parole, or life, you will all sign your appropriate. That is the document, and that is where you record this verdict. Does anyone have any questions? We're going to send to you also part of the exhibits that you saw during the guilt-innocence phase of the trial, because you're required to consider the facts that have been introduced at the guilt-innocence phase of the trial, as well as in sentencing. And if there's anything else you need to take a look at, let me know. We'll get it to you. You may now retire to begin your deliberations on the case and report back to the court the verdict, the sentence that truth dictates and justice demands. You may follow that, and I wish you Godspeed in those deliberations. For the record, jurors, I will ask for the majority in this case. It probably wants to give your contact information to Madam Clerk once you have a question or a verdict. We'll summons you back for that purpose. We'll call a court recess for 2 minutes. We'll get set up the regular docket, and we'll call the regular calendar while the jury is deliberating, everyone remains seated.
Remain seated for 7